for joining Vesta Property Services for our 2021 Legislative Updates webinar. My name is Leslie Fergassum, Vesta's Business Development Manager. Before we begin, I'd like to go over a few housekeeping items. To avoid disruptions, all participants will be muted and the ability to join with video has been disabled. Participants will receive a copy of the presentation and a certificate of completion via email within the next few days. Questions will be answered at the end of the course, should time allow. You may submit questions via the Q&A button located on the toolbar at the bottom of your screen. All CAMs needing CEU hours for the renewal of their CAM license must remain on the webinar for its entirety. Following the webinar, you will receive a survey. Please complete the survey, which will ask for your CAM license number. Please keep in mind you must stay on the webinar until the end. Vesta Property Services is the industry leader in community association management and has been servicing Florida communities for the past 30 years. With 17 offices located throughout the state, Vesta provides association management, amenity management, and district services to over 800 communities throughout Florida. Joining me this evening is Vesta's General Manager of the Southwest Florida region, James Tanagawa, and Colby Keefe Esquire with the Henderson Franklin Law Firm located in Fort Myers, Florida. James has worked in the association management industry for the past 14 years and has been a general manager with Vesta since 2008. He oversees our offices in Bonita Springs and Naples and services the surrounding areas. Colby graduated from the University of Georgia School of Law in 2016 and has been practicing for 5 years. Her focus has been community association law, including general counsel, litigation and mediation, and collections on behalf of associations. Additionally, Colby practiced for some of the premier community association attorneys and firms in Northeast Florida, where she began her career. In 2020, Colby was named a leader in the law by the Florida Association for Women Lawyers. Thank you, Colby and James, for taking the time this evening to discuss legislative updates as it relates to community associations. At this time, I will turn it over to James and Colby.
Leslie, I'd like to thank you for the introductions, and Colby, I'd like to thank you for joining us and being part of the discussion this evening. Most importantly, I'd like to thank our attendees, both board members and CAMs alike. We are collectively on a day-to-day basis faced with a number of unique challenges and situations that we can see ourselves through by enriching our knowledge and understanding of community association matters. Now, I'm just a layperson, a general manager, right? I've been doing this for a while, but we are very fortunate to have Colby with us, who is a scholar in matters of association law, and help provide us with guidance on not just how we deal with what we're faced with at present, but how we can plan for the future. So if at any point in time anybody has any questions, feel free to submit them via the chat. We will entertain those at the close of the presentation, whether they be questions for Colby with respect to the rich subject matter that'll be discussed this evening, or if there's questions for me with respect to how Vesta Property Services can provide solutions to problems your association is facing. We'd be happy to discuss later. Without further ado, I'll turn it over to the person who has knowledge on what we're going to be discussing, Colby. Thank you.
Thanks, James, and thanks, Leslie, and all of Vesta for helping coordinate this. As James mentioned, it's really helpful to have you all as the participants, not only CAMs, but also the board members. Legal updates each year can be very, very dense. And there's a legal side to things, but there's also, of course, the practical side. And I think it's really helpful to have, the anecdotes and share questions and answers to really kind of figure out the application of some of these laws. That's, I think, the best way to really familiarize with them and put them to good use in your communities. So with that being said, this is the 2021-2022 legislative update. Just a couple brief notes on this course and the material that we'll cover. So for the CAMs, you need, I believe it's 3 credit hours of legal updates in each cycle period. And the next cycle deadline is the end of September of next year, I believe. So this is good for 2 of those credits. You'll still need a 3rd credit, of course. But we will take care of getting those credits submitted. I'll work with Vesta to get your CAM license numbers after the presentation to submit those. And for the board members who are joining us, this of course isn't mandatory for you, but it's very, very helpful, of course, to learn what new laws are coming down the pipeline and what's going to be implemented this year. I think that the more courses that you can take, if your time allows, the easier it makes your voluntary job, which already doesn't have great pay, right? So we will send out a certificate of completion should you wish to keep that with your official records for the CAMs. Like I said, we'll take care of getting those courses credits submitted to the DBPR. And the course material itself. So these 4 Senate bills that are listed here, the legislation that passed, these are the Senate bills that DBPR requires to be included in this material. What I've done is parsed through those bills for what I consider to be the most relevant past legislation for your daily operations. If you look through each of these bills, there is a variety of sections that I don't really think will come into play in your day-to-day operations. And we simply don't really have time. And I know I don't have the attention span to weed through all of the density of those. But I think that we've picked out what's most important, like I said, for you to do your job, CAMs and board members alike. The other thing that I wanted to cover when we finish up, and of course, time allowing, is kind of discussing what maybe we can look for on the horizon with the next legislative session. So obviously with the terrible Surfside building collapse, I think that we're going to see some legislation proposed in response to that. And I think it's helpful to just get an idea of maybe what's coming, because it can affect your operations now if you have an idea of what to expect with next year's legislation. So I'm going to go ahead and jump in to Senate Bill 56. This is what I consider to be one of the most important changes that was implemented. And I say that maybe because I have a background in doing collections work for associations, but obviously your ability to collect delinquent assessments is the lifeblood for your community operations. If you don't have money to do projects, you're kind of at a standstill. So Senate Bill 56, first of all, it increased the time frame in condos and co-ops to mirror that of HOAs. As those of you in HOAs know, the timeline for owners to pay an amount due after receiving an intent to lien or an intent to foreclose has been 45 days. It's always been 45 days in HOAs. And by that, I mean, when you send out an intent to lien, that owner has 45 days to pay before you can take the next collection step. Condos and co-ops was previously 30 days. So there were 30 days to pay before you could proceed to the next step. That has been increased to 45 days. So it's across the board, condos, co-ops, and HOAs, it's now 45 days. That in itself is, I think, relatively straightforward, but I do want to make a point on that because I've had this come up for some clients. Let's say that you sent out an intent to lien in a condominium on June 28th. This law took effect July 1st. It doesn't apply retroactively, meaning that letter you sent on June 28th, at that time, 30 days was the deadline. I think that it's defensible and based on the law at that time, you could proceed with recording a claim of lien on July 28th, which would be 30 days from the date that was sent, even though the new law says 45 days. Now, when you send that intent to foreclose, which is the next letter, now you need to use the 45-day deadline because the new law is 45 days for that next demand letter. It's a pretty narrow window of time there that you probably have that issue come up, but I have seen some clients already struggle with the rules on this and how it applies to pending collection matters. The next big chunk of Senate Bill 56 that is going to have a big impact on collection of delinquent accounts is this notice of late assessment. And this is applicable to HOAs, condos, and co-ops, all three. So previously, if you wanted to send the intent to lien, although it might not be the best practice, you could put it on attorney status or send it right to the collection agency without worrying about adding those attorney's fees to the owner's account for collection, because costs incident to collection can generally be recovered from the owner. This new law requires a notice of late assessment to be sent before you can start collecting for attorney's fees. It's limited to attorney's fees, so you can still, if there's, say, a management fee of $10 for preparing the notice, that can still be charged back to the owner's account. But this is important because you do have some communities that, for whatever reason, if they've had perhaps a history of delinquent accounts that have gone stale, are, I don't want to say trigger happy, but like to put things on attorney status quickly to make sure that they keep those AR balances in check. Before you send things to your attorney, just be aware that this notice of late assessment needs to be sent and give the owner 30 days to pay before you can start adding any legal fees. And the way that this is written, it would apply to not only legal fees for preparation and sending of that letter, but I think all subsequent legal fees as well, which is really important. Because if you get to the point where you have a lien recorded and you're trying to file a foreclosure action, you might have waived your ability to collect any attorney's fees if you didn't send out this notice of late assessment. So you definitely want to make sure that you update your collection policies here. There is a template in the statute. So, if you maybe need to get a letter out quickly, you can copy and paste that, of course, supplement the correct figures, but there is a statutory template for this notice of late assessment to send out. And finally, delivering statements of account and invoices. This section, I would be very surprised if we don't see it corrected and kind of cleaned up next year. But this section, the new law states that before the association changes its method of delivery for sending statements of accounts and invoices to an owner, they must receive the owner's written acknowledgement of that method of delivery change. And you have to wait 30 days before you can send that to the new method of delivery. So in practice, what this means, basically, this was enacted in response to situations where the association changes a mailing address and then an owner comes back and says, well, I never got it. I didn't tell you to change my mailing address. In some ways, I think this can be beneficial to management companies. I'm sure James and some of the managers on this call have run into issues where you have a collection matter and you have to settle because there's some technicality and evidentiary issue with notices being sent and received. This, to this bill's credit, it will minimize some of those technicality defenses because it makes it clear. One of the problems that I have with this change is that I don't really understand why the 30-day requirement is in there. A lot of the time, really, it should be all the time that you're making a method of delivery change. It's because the owner has reached out and said that they have a different mailing address they want you to use. I don't like that if the owner on their own volition and motivation sends in that request, the association then apparently, based on the plain language, has to wait 30 more days. That's just my personal opinion. I hope that this gets cleaned up, but I do think this is could be a little bit of a headache the way it's currently written, and hope to see it get cleaned up a bit next year. So that's the Senate Bill 56, and like I said, those collection changes I would consider them to be some of the most significant that we saw this year in the legislation. Definitely, get with if you have legal counsel, your management companies, Vesta can help you kind of clean up your collection policies to make sure that you implement these changes, but you will want to take a look at those and make sure you're getting these notices sent out. They took effect July 1st. Again, for notices sent prior to July 1st, pending delinquent accounts, you don't need to worry about it, but any subsequent notices sent after July 1st, this bill will take effect.
Colby, if I might just interject and add something for a quick moment for our existing clients who may be inquiring, the final notice that we typically send to delinquent owners has been augmented in such a fashion that it fulfills that statutory 30-day notice of late assessment to the owners, so that we're not, appending time to the the collection table you've become accustomed to. It'll flow in the same regards, in the same time frame, except, we have to follow the 30 days that the state requires, but we have all necessary language in that letter to fulfill the requirement. Thank you.
Yep. Thanks, James. Yeah, and a lot of management companies, just as a matter of good practice, you really don't want to get in a situation where you're not able to collect. You want to make contact with these owners so that they can pay. So definitely best practices to get a notice out anyway. Okay, so I'm going to jump into Senate Bill 630 now. This is what's called the Omnibus Bill, and it's basically just an entire array of new laws across the board. Before I get into the substance, I do want to say the way I've organized this, we're going to go through the changes that affect condos and then co-ops and then HOAs. You're going to see some of these things repeated because there were quite a few of these new laws that are applicable to condos and HOAs and co-ops or any combination thereof. So I'll go in detail the first time we visit it, and then subsequently, if it's under the HOA slide as well, we'll just kind of gloss over it a bit. So first up, we've got the subrogation rights. So this section of Senate Bill 630 regarding subrogation rights, this is really more, this is going to impact the insurance industry more than your daily condominium operations. But basically, this says that if the condominium association's property insurance policy doesn't provide for subrogation rights, a unit owner's individual HO6 policy can't then provide for subrogation rights against the association. So basically, if you have a situation where this is really directed at condominiums, stacked vertical condominiums with water leaks. That's really what this was intended to address. And there were a lot of situations where a homeowner's HO6 policy had rights of subrogation, giving that insurance company the right to then pursue claims against the association, saying that the association was actually at fault, for some negligence of maintenance of the common elements and things like that. This is intended to really allocate the risk between insurance companies, because in practice, if a unit owner, if this comes up, the association's insurance policy is going to pick it up anyway. So really, it's just a way for the insurance companies to allocate this risk. And I can tell you that in my experience, and I don't know if we have any insurance professionals on the call, but in my experience, I think most association policies provide for subrogation rights. So already, and I don't really see this having a, tangible impact on daily operations, but it's, good to know the association does, in theory, have the authority to, kind of dictate whether subrogation is at play or not. If you could shop around and get a policy without subrogation rights, that means that a unit owner can't then seek subrogation from the association. Next, we've got the 8-year term limit. And this, for those of you who are in condominiums, you probably are familiar with the headache of this 8-year term limit. The lineage of this dates back to July 2018. You can see there. This first was enacted in July 2018 with some kind of vague language that the courts and arbitrators have struggled with, as well as board members and CAMs and attorneys. And the way it was initially enacted, I think it said that board members could serve no more than 4 consecutive 2-year terms. Well, that raised an issue of, okay, well, how many 1-year terms can you serve? Leave it to attorneys to try to find some wiggle room out of a rule. But basically, this amendment was intended to lay to rest the 8-year term limit. You start calculating the 8-year terms on July 1st, 2018. So basically, this really isn't going to start terming people out until 2026. But the full rule is that individuals who have served 8 years in that time frame can't run for the board. With that being said, if you're in a community where you have a struggle to get people to volunteer on the board, obviously you're not going to prohibit someone if they're one of the only candidates willing to serve. You're not going to have a vacant seat just to comply with this rule. But this does clarify that 8-year term limit begins counting from July 1st, 2018. The next, this section regarding multi-condominium associations, we have a lot. I've noticed in Southwest Florida and Northeast Florida had, I think, less, but still some. There are quite a few multi-condominium associations, meaning multiple condominiums in condominium complexes and phases are operated by one association. And sometimes this is done in phases such that there are multiple declarations and sets of governing documents, and it can get very confusing, as you can imagine, with condominium 1 declaration, condominium 7 declaration. Basically, this memorializes the practice that attorneys have already been doing. The statute didn't previously speak to adopting consolidated declarations. It didn't prohibit it, but it didn't specifically allow for it. This was intended to specifically allow for adopting consolidated declarations in those multi-condominium associations, basically as a way to clean up that situation where you've got multiple sets of documents and you're trying to get the membership to approve one concise, comprehensive set of documents, and it's called a consolidated declaration. So let's jump into the changes to the official records here. And the official records section is just, I would say, constantly changing each year. We see some changes to this. So first, official records, bids for work previously were required to be kept for 7 years. This is now 1 year. And actually, if you back up, I think it was 1 year and then it went to 7 years and now it's back to 1 year. So that just alleviates some of the administrative burden on keeping those bids, especially, and it makes sense. I mean, if you have bids that you didn't hire that contractor, it really doesn't make sense to keep those for more than 1 year. It's just not necessary. So this is probably just some cleanup and responding to, common sense. This Senate Bill 630, this also clarifies the limit that renters have in requesting to inspect official records. So they have the right to inspect the declaration, articles, bylaws, and rules. I think previously it was an oversight, but it only specifically listed articles, bylaws, and rules for the renters to inspect, which doesn't really make sense because the declaration is where you see, I think, most of your use restrictions. So this just clarified what renters are entitled to get as tenants of the association and doing an official records inspection request. The next change to the official records section is, I think, intended to just kind of modernize the shift that we're seeing with websites and using apps, on like a smartphone, you would download an app. This makes it possible for condo associations of 150 more units, which of course have been required to have a website. This makes it easier for them and expands their ability to comply with that by making some of these documents available through an app. Again, I think we'll probably continue to see some of these types of changes just with response to ever evolving technology. Most of the time, your website vendors will have some sort of package where there's an app available to download or something like that. And this is, I think, just meant to cater to those situations. And finally, I think most attorneys would tell you that you should never require a member to state a reason for inspecting official records. That's a no-no. But this very clearly states that you cannot require a member to state a reason for inspecting the official records. They don't have to, give you a reason, and the only thing I'll say to this is we've all seen people who maybe as a nuisance practice like to make multiple requests in the same week. Sometimes I've even seen. You still are allowed to adopt reasonable rules and regulations regarding official records. You can still do that. So, I've advised clients to state that, a certain amount per month or per quarter can be requested. You just simply can't make them state a reason for that. So you can still adopt your reasonable rules and regulations, though. So next we've got the increase in transfer fees. And this is really more, I would say, probably more in the purview of your management professionals. Transfer fee cap used to be at $100, and that was increased to $150. And they've also put language in there this year that will increase it every 5 years based on CPI, the consumer inflation rate. So what I'll say about this, though, is, if you have the opportunity to amend your documents, and this is a great example of this, sometimes it's best, less detail is better. If you're amending your documents, you maybe don't want to put $100 or $150. Don't state an amount. It's probably best to say the maximum amount permitted by statute will be collected. That way, if the legislature goes in and increases this to $200 next year, you're not having to scramble and update your docs every single time. And that's true of a few sections that we'll cover, and there are a few areas of the acts that it's best to just incorporate the automatic updates, and this would be one of them. So if you've got the ability, sometimes it's through your rules and regulations, which is usually a simple board vote. You'll want to take a look at your transfer fee. If it sets a specific amount, now would be a good time to increase that and state that it's the maximum amount permitted by statute. And this next item, so Senate Bill 630, it removes, there was previously a blanket prohibition on the association being able to contract with companies in which a director owns or operates that company. So that prohibition was removed, but I do want to say to this point, that doesn't mean that, you're free to enter into those contracts, left and right. You still have to disclose potential conflicts of interest. And that's required by the Not-for-Profit Act. And so, there are still other rules that pertain to contracting with companies in which a director, has an interest. So keep that in mind. I think this removing this prohibition, I think, was intended to just clear up some conflicting sections, but you do still have other rules in place there that would affect that. Okay, condominiums part 2. So there were a lot of changes affecting condominiums in Senate Bill 630. So I think a couple of years ago, I'm trying to remember when, but the rule allowing the electric charging stations has been in place for, I think, at least 2 years now. And this year they expanded this to allowing owners to install natural gas fuel stations. I do not know how many people this affected. I have not had any clients have a natural gas fuel station request come up. I've seen the electric charging station requests, but maybe the legislature was trying to be ahead of the game on this one. But the important thing on this, I think, is, of course, it's expanded to allowing owners to construct their natural gas fuel stations. And what I think is more important for CAMs and board members to be aware is that the association is entitled to construct its own, association controlled and operated charging stations and natural gas stations, but that doesn't mean that you can then prohibit owners from constructing their own. In other words, just because the association makes one available doesn't mean that an owner isn't entitled to do their own, charging station or natural gas station. The other thing too, and this has been true of the electric charging stations, but you have the ability to require that owner, of course, they pay for the installation, but they also pay for the removal, and you can require them to remove those, upon sale of a unit and moving out of the association. This next item, frankly, I was surprised that this wasn't already in the statute. I think this is just something that maybe had been missed, and the legislature recognized that. But previously, the Condo Act didn't set a default for the special meeting notices. That has been corrected. The default is now 14 days. So if you have a special meeting of the members that's being called, if the documents are silent, you need to give at least 14 days. Now, the documents can specify otherwise. So if your bylaws say that a special meeting of the members can be called with 10 days notice, that would still prevail. You would still have 10 days as the rule. But if your documents are silent, this 14-day default is going to take effect. I think this, was probably intended to respond to situations where you might have communities with a lot of snowbirds, And I can't say I've had my clients do this. I would advise them otherwise, but you hear stories, of course, of, people trying to kind of game the system. If you've got a controversial issue, let's say there's a rule that will adversely affect your snowbirds, you might want to try to call that meeting and hold a vote while they're gone, or they don't get requisite notice to make arrangements to attend in person or by proxy. So this sets the default at 14 days, kind of curtailing those kinds of efforts. So these next a couple of these next items, these are really more going to affect your legal counsel, and this is with respect to disputes with owners and recall disputes. So previously, the disputes that were to be arbitrated, as some of you guys know, there are some disputes that have to be arbitrated, submitted to arbitration to the DBPR. This new law expands your options for arbitrating or now mediating those disputes. So instead of having to resort to DBPR arbitration, you can now opt for mediation. And this is consistent with what the HOA Act has always required, which is pre-suit mediation. And in my experience, I find mediation to be extremely helpful. So this to me was a huge win for condominiums. For my condominium clients, I will most likely be recommending that they seek mediation for a lot of these disputes instead of the arbitration process. Mediation is, each party bears their own costs, of course, but it's usually a pretty good way to, one, of course, try to reach a resolution, but two, it can give you a pretty good idea of, if it does proceed to litigation. It's a great way to, figure out what their arguments are, how strong your arguments are, and maybe deciding, okay, is this worth it for us? So this, like I said, I think this was a big win for condominiums associations. I think it's great that they expanded the ability to mediate to condo associations. You can still petition the DBPR for arbitration. You do still have that option. It just expanded an option of mediation as well. This next one regarding escrow funds, this really is probably only going to pertain to those associations that are still developer controlled or very recently went through turnover. But there's been some confusion as to what a developer can use escrow funds for in the construction of the condominium association. So this clarifies that the developer cannot use those funds for marketing fees and attorney's fees, which, that makes sense. It's one thing if you're using escrow funds for construction and the development, but if you're using escrow funds to sue those people whose funds they are, obviously you got a problem there. So they can't use those for marketing fees and attorney's fees. Again, this probably really only applies to communities that have very recently gone through turnover or have not yet gone through turnover, but it's still an important one for those. Next, we've got this section regarding permitting associations to unilaterally extinguish discriminatory restrictions. Luckily, I really haven't seen anything, egregious in my years of practicing regarding discriminatory restrictions, but you do see them, particularly, I think, in the 40s and 50s. There were some restrictions enacted saying that people of certain religions or, ethnicities could not purchase, into communities. This basically gives the association, by simple board vote, the ability to amend and remove those sections. And that's really important because under the Fair Housing Act, simply publishing restrictions like that, even if they're not enforced in practice, it's akin to strict liability, because even just by publishing it, you might be deterring someone who sees that from buying. So even if the association hasn't been actually enforcing that in practice, and hopefully they have not, if you have legal counsel, they surely would tell you not to. But even just publishing it can expose the association to liability. And the other point I want to make about this is discrimination. We think of it as age, ethnicity, religion, things like that. And something typically in really plain terms, like, someone of this religion cannot purchase a unit. But you need to be careful because age discrimination can be a little less, it's not as easy to spot. I've helped clients revise pool rules, for example, that said minors could not use the pool if they were unattended by an adult. And so this is, I think, a good opportunity for you to look through your community documents, see if there are any rules that are drafted with one of the conditions or triggers being a protected class, which would be, religion, age, race, ethnicity, disability, those types of things, because you might, unknowingly be publishing and enforcing something that is considered discrimination. So you definitely want to check through your documents and see if there's anything that falls under this category, and take care of that, using this simple board vote, which makes it much easier to make those changes. Recall disputes, these previously had to be petitioned to the DBPR, again through arbitration. This has been expanded, not for mediation, but now you can actually go ahead and file a suit in court. So you have the option to arbitrate or file a lawsuit in court. I would not, as a practice point from the legal side, I don't think most judges would take kindly and probably would be frustrated to see recall disputes filed. If you have a judge who sits on the bench all day and sees disputes that have to do with, domestic abuse, things like that, some pretty heavy topics, and then you have, a condominium come in and file a recall dispute. Unfortunately, I've seen judges, maybe it's for, not lack of having experience in it, or you just kind of not wanting to deal with it, but I would err on the side of continuing to use arbitration on these things, because I just don't think that most judges will necessarily view these kinds of disputes favorably for the association. So that's, again, it does open the door for filing a lawsuit for recall disputes. I don't necessarily think that's the best option, though. I think petition for arbitration is probably the best here. This next change clarifies that a fine, when an enforcement committee has approved a fine, so if you've gone through the long, arduous steps of the fining process, some of the board first votes for the fine, but then it doesn't actually take effect until a fining and enforcement committee has noticed with at least 14 days, noticed the hearing, given the owner an opportunity to attend and kind of present their side of the story, and then voted to approve that fine. So this is a two-step process. Previously, the statute was unclear and frankly confusing. It said, I think that the fine was due at the time the committee approves it. Well, that strictly interpreting it, means that it could be due at the meeting before the notice has even been sent. So this just clarifies that the fine is due 5 days after the notice of the approved fine is sent over to that owner or tenant who the fine was levied against. And that's a duplicate. I already covered the recall and election disputes. Those can be, again, arbitrated or filed in court. And then these additional emergency powers. So we saw a lot of changes to the statute that were intended to address COVID-19. The previous emergency powers section of the act really was contemplated with hurricanes and natural disasters in mind. And I'm sure many of you saw the struggle of trying to, fit the COVID-19 pandemic into that emergency powers section. And it was just very difficult to do. In most cases, communities had to adopt all new, rules and bylaw amendments to allow virtual meetings and things like that. The issue that I have with the changes they made to the emergency powers, and I have a separate slide that I'll get to because this is one of those things that applies to condos, HOAs, and co-ops. But the biggest issue that I have with the changes they made is that it's only triggered when there's a state of emergency. And as we know, in Florida, this is no longer a state of emergency. I think, I can't remember when, but it has not been a state of emergency for months in the state of Florida. So I don't really think it contemplated, and probably rightfully so, situations that we see now where there are now variants of COVID-19, and you have these lingering issues that could prohibit in-person interaction, but don't rise to the level of triggering a state of emergency and triggering those emergency powers. So I'll talk about this more, like I said, and get more detailed as to what those changes were in a couple slides here. But again, this is only triggered when there's a state of emergency. So I think we'll see some, see this flesh out, and probably some revisions to this in the next legislative session to address, that situation I just explained, where there's not a state of emergency, but you still need some additional powers in place there. So I'm going to jump over to the co-ops now. And to be honest, I really haven't seen a lot of co-ops in my practice. There was one client in Northeast Florida that we had that was a co-op, but they're just really not as common in Florida. So I'll breeze through these, but for those of you, if we have any co-op, CAMs or board members, please feel free to, share your questions. I certainly don't mean to ignore you. I just, we don't deal with a lot of co-ops in our practice area. So this first thing here, this is actually an interesting change that they made. So previously there was conflicting case law on whether a co-op is considered an interest in real property. And this was tested in multiple cases and really came up with debtors' rights, because as some of you know, you have a homestead exemption. If you're going through bankruptcy, there's a homestead exemption, and your homestead is, cannot be sold or foreclosed on. And there were conflicting cases saying whether a co-op was or was not considered real property. So I think in part this was intended to clarify that. By stating that it is real property, of course, you have those debtors' rights implicated, but it also means that, trying to restrict sales and transfers in co-ops, you now have to deal with and consider unreasonable restraints on alienation. So if you have someone who has a property interest, you need to be a lot more careful now. If you're trying to decline and refuse a transfer, you're probably going to have a corollary obligation to produce an alternative purchaser. So, if you're in a co-op and, if this is applicable to you, definitely take a look at any of your rules and regulations that would implicate, those real property rights that your owners now have. This is memorialized law now, that it is a property interest. These next points, I think these are duplicates of the condominium rule, so I'll just kind of breeze through these. But the emergency powers, again, these were expanded to permit board and committee members to appear and vote virtually. Again, this is part of that emergency powers that I'll get to in a minute here. It's only if there's a state of emergency. Official records, as with the condominiums, you can't require members to state a reason for inspection. As with co-ops, as with condominiums, you are now able to arbitrate or mediate disputes. Again, I think mediation is the best avenue in most situations for those types of disputes. You can extinguish those discriminatory restrictions, and recall disputes can also be arbitrated or filed in court. These next two, again, just duplicates. We'll get to the emergency powers in a minute here. So let's jump into the HOAs. And first, we've got, this was a definition change, and who knew that changing a definition could have some serious implications, but it does. So for HOAs, the new definition of governing documents removes rules and regulations. And it states that governing documents are defined as your declaration, articles of incorporation, and your bylaws. This has swiveled back and forth. So it was previously, I think in 2017 and prior, the governing documents were your declaration, articles, and bylaws. That's how it was defined in the HOA Act. And then I believe in 2018, I might be wrong on the year there, but give or take around 2018, that was expanded to include rules and regulations as a governing document. Well, this kind of set some HOAs into a frenzy, and rightfully so, because other sections of the HOA Act refer to amending your governing documents in quotes there, and them taking those amendments taking effect when they're recorded. Well, not all communities had been, as a practice, recording their rules and regulations. And when I say rules and regulations, that can be your architectural guidelines. Sometimes it's rules and regulations regarding renters, things like that. Usually it's by board vote, that had been enacted and had not been recorded. The other thing, that's implicated there is there are sections of the HOA Act that say, for example, fines. There's a default amount for fines of $100 per fine up to $1,000 limit in the aggregate, unless your governing documents specify otherwise. And so, the good thing about adding rules and regulations to the definition of governing documents back when it was done in 2018 is that this allowed HOAs to, by board vote, pass, a resolution or a rule regarding fining and change that fining amount. Instead of having to go through something like a membership vote, amending your declaration or potentially your bylaws. So fast forward now, July 1st, 2021, we've got this new rule, which reverts back to the governing document definition, which does not include rules and regulations. And so a couple practice points that I think are important to cover here. I have very recently dealt with disputes where the association was trying to enforce an architectural guideline. Guidelines were not recorded, and the opposing attorney, raised that as defense, saying that those rules were not recorded, and there was an argument that they therefore had not taken effect because they were not recorded as required by the HOA Act. So there's still a window of time there that I think you want to check with your legal counsel. If you have rules and regulations that you adopted between 2018 to July 1st, 2021, I think those need to be recorded. Now, in theory, from July 1st and on, because rules and regulations are no longer part of that definition, you can make an argument that you no longer need to record amendments to rules and regulations or new rules and regulations that are adopted. But as a best practice, it's really best to continue recording those kinds of things in the official records. By doing so, you put owners on constructive notice, even if there isn't, actual, hand-delivered notice of something like revised architectural guidelines. You always have that fallback constructive notice argument if those documents are recorded in the official records of the county where your community is located. The other thing, to consider for those of you who did, for example, implement changes to your fining amounts or other changes through rules and regulations, you want to take a look and see, if any of those changes are jeopardized by this change in the definition of governing documents. And one more point I'll make on that, the Act provides this governing documents definition, but that doesn't mean that your declaration might specify what the definition of governing documents is too. So if your declaration says that the governing documents are limited to your declaration, articles, and bylaws, you're probably good to go here. You're consistent with what the Act now is, but that's just something to check for your document, see if it speaks to that definition and how that would interplay with this change in the HOA Act. So if I never have to say the phrase governing documents again, I would be happy, right? So next, moving on to this rental restrictions change. And this is, I think, was originally going to be a pretty big change, but then they fit in an exception here. So we'll go through it, but this rental restriction in HOAs now, this basically says that if there is an amendment that the association passes prohibiting or restricting rentals, it will only apply as to those persons who vote in favor of it. And for those who vote against it, it doesn't apply immediately. It will only apply upon a conveyance. And that's further defined to basically be like a voluntary conveyance to a third party. So if you pass away and your daughter takes over the house, it wouldn't apply because that's not considered a voluntary conveyance. Now, there is a huge exception here that says amendments prohibiting durations that are 6 months or less, or amendments which limit the number of times a home may be rented to 3 times per calendar year would be applicable across the board, regardless of whether that an individual votes in favor or not, assuming, of course, that it gets the otherwise requisite membership vote to pass. So, most often if you see rental restrictions being implemented, it's probably in the context of what, is casually referred to as short-term rentals. I mean, it's not typically your long-term renters that you see associations making rules about. So this exception, which says that any amendments prohibiting durations that are 6 months or less, that's going to be most of your amendments probably. So, I think that's a win for associations because, initially the initial versions of this rule before it was, finalized, I think it looked to me like it was going to have a much wider spread impact and limit the association's ability to, amend rules and restrict rentals. But this still allows the association to amend for 6 months or less, and it will apply across the board. It's only those amendments which would be over 6 months that would only apply to those who vote in favor, assuming again that it does pass. And I did briefly discuss that change in ownership. The act goes into more definition, but like I said, this is really going to only apply to voluntary transfers. So, an involuntary transfer, or if you put it in an LLC, maybe which of course this would come up if you have a rental property that you're renting out, you might want to put it in an LLC. If you're the only member of that LLC, that's not considered a change in ownership for purposes of this. And that only applies to HOAs with 16 or more parcels. So here, Senate Bill 630, we saw a couple changes to the official record section in HOAs as well. Sign-in sheets, voting proxies, ballots, and all other papers relating to voting must be kept as official records. As a practice, I think this was already being done. This is another change that I think just memorializes the longstanding, practice and rule and counsel that attorneys have been giving. This next one is one of my favorites because I was involved in it. So guest logs kept in connection with visitors to gated communities are not open to inspection by members. Leslie, I'm sure you've probably heard my former colleague, Ed Ronsman, who I worked with in Northeast Florida. We had a client who, and this was an HOA, of course, reached out to us because they were having some issues with official records inspection requests. And this is a community that had some politicians, I guess I would consider important politicians in Florida residing in the community. And this was becoming a real problem for them. And we sent them an opinion saying, under the current Official Records Act, as some of you all know, there's a catch-all that says any other documents relating to the operation of the association. If you're taking names or you're keeping a guest log, that's technically an official record. And in response to that, they worked with some of those, I think, individuals and got this fit into the official record. So this only applies to your HOAs. It doesn't apply in condominiums. I don't know if that will be expanded. I think it was, again, probably an oversight. This was, in my opinion, and I with that background, I think this was a very specific issue that was addressed in an HOA. So I don't know if we'll see this expanded to the condos. It maybe isn't an issue for them as well, but just some interesting backstory there. Again, this is another duplicate, but associations, HOAs are also permitted now by board vote to get rid of any of those discriminatory restrictions. So again, this is an opportunity for you to look through and see if there are any. Most likely it would be potentially age discrimination rules, whether it's on the common areas or otherwise, to change those by simple board vote instead of membership vote. As with the condos and co-ops, recall disputes can now be filed in court as well as arbitration. And again, a fine, if a fine is approved by the enforcement committee, it's not due until 5 days after that notice of fine is sent to the owner and tenant. And these next two, again, duplications for the recall and election disputes and the additional emergency powers. So we've got a couple more things that are specific to the HOAs here. These reserve accounts, and this is another one that this is going to apply more to your communities that, again, are either going through turnover or recently went through turnover or are about to go through turnover. And this was in response to case law on the issue of whether a developer is required to fund reserve accounts. For those of you who have gone through the turnover process, you're familiar with the phrase deficit funding. And this is a way for HOAs to, for developers to cap how many assessments they pay if they guarantee a certain amount. And then if of amount expended, and if the actual amount expended in the operating budget exceeds the assessments they've recovered from those non-developer owners, they promise that they'll pay the gap, basically pay the deficit. That's deficit funding. But there was a case in which the dispute came up whether reserve accounts were considered part of what's covered in that deficit funding. And that case held that the developer was required to pay toward those reserve accounts, even if there was deficit funding elected. Well, now here we have the legislation responded to that and came out saying that's not the case. If deficit funding has been elected, your developers do not need to pay into those reserve accounts. The other thing too here is where the developer has set up reserve accounts, those have historically been considered mandatory for the association after turnover. The association was also able to provide for reserve accounts by getting affirmative approval of a majority of the voting interests, even if the developer had not set up reserve accounts. Of course, some HOAs want them. That's now no longer the case. So just because a developer sets up reserve accounts, they're not considered mandatory anymore. This really puts the power into the association and the members post turnover to decide if they want by affirmative vote, affirmative approval of a majority to provide for those reserve accounts. I think this is a good change because, the developer, sometimes they might go through the motion and, they've done a lot of condominiums where you have to have reserve accounts, and maybe just as a matter of, practice and ease on their end, they do the same, go through the motions with HOAs. But sometimes your HOAs don't want those reserve accounts, for a lot of good reasons. So you don't want to bind the members after turnover to fund those reserve accounts. It puts the power in the membership's hands to vote in favor of reserve accounts. And finally, this last one, there's some clarification on the forced turnover provision in the HOA Act here. So as some of you guys know, the HOA Act speaks to when turnover must occur. And previously, the Act didn't clarify sales conveyances to members other than the developer. That language has been added to clarify that 3 months after 90% of the parcels in all phases of the community that will ultimately be owned, by non-developer owners other than developer or sold, turnover is triggered. Okay, so and excuse me I've been losing my voice. I went to my nephew's high school football game last week and was over enthusiastic because he's a sophomore on varsity, and I lost my voice cheering. So bear with me. So as I mentioned, we've got a few changes to the Condo, HOA, and Co-op Act in response to, frankly, directly in response to COVID-19. So the intention, I think, when they were drafting, they went through multiple revisions, of course, of these changes, and they were trying to address COVID-19 in situations where, as we saw, basically operations shut down for a brief period of time there, and then trying to figure out how to pick back up with meetings and do it safely without exposing the association to liability, and also, frankly, without putting members and board members at risk and managers too. So I think what they came up with is still lacking. Frankly, I think we'll see changes to this, and I hope that we do. But the new changes that they've implemented, expanded emergency powers when a state of emergency is declared. So it is conditioned on a state of emergency being declared. But it does give the associations the ability to conduct board meetings, member meetings, elections, and committee meetings by virtual means. So that can be telephone, it can be Zoom like we're using here, any real-time video conferencing where the participants can participate here in real time. It does give that option, again, when a state of emergency is declared. It also gives the board the ability to name assistant officers. I think, again, obviously, if you have a situation where someone has become, unable to serve for whatever reason, you can name assistant officers. They do not have to be current board members to serve as officers. And the association also, this specifically provides the association with the right to determine that portions of the association are unavailable for entry or occupancy in response and upon the advice of various professionals. So I know I saw this in a lot of communities that I helped with, and I appreciate this language being added because you all probably saw it as well. But at the beginning of COVID-19, if you had a community pool, for example, and you needed to close that, or the association decided to close it temporarily, I saw a lot of owners trying to use that as an excuse, to not pay their assessments, saying that because the amenities weren't being available to them, they no longer had to pay their assessments for maintenance of those amenities. Of course, that's a bogus argument, but having language like this just really helps kind of refute those kinds of things that did come up. And I do want to speak on these emergency powers. Like I said, I think we'll see this expanded to fit the current situation where we have these lingering, variants of COVID and all kinds of situations that, frankly, the statute still really doesn't address and contemplate. But one thing to keep in mind is that conducting these board meetings, so sometimes the documents will specifically say that board meetings are to be held in person. A lot of communities went ahead and amended their documents during COVID to, fix this issue. But if your documents are silent, you can look to the Not-for-Profit Act. And that can be a useful tool to supplement your condo and HOA acts, because the Not-for-Profit Act, I've relied on a few times for clients to hold those meetings virtually, because it does provide, it's section 617.0820. And it provides the ability to hold those meetings virtually. Again, that would only be if your documents don't specifically contradict that and specify otherwise, but that is a useful tool. So that wraps up Senate Bill 630, and there are a few other changes in Senate Bill 630 if you want some pleasure reading. It does get fairly dense, but I think that kind of summarizes the big changes that you'll see really take an impact on the daily operations and for you all, the board members and the CAMs. So we'll jump next to, this is Senate Bill 1966. And the Condo Act has long stated that board eligibility is limited to people who are current in paying monetary obligations. So this year, they amended that to state that a person delinquent in payment of any assessment rather than any monetary obligation is not eligible to be a candidate. So I think this, again, I didn't have this happen. I've heard horror stories, though. And it happens in communities where you have kind of a problem child and they say, well, I'll just run for the board. And then the board is, of course, frantically kind of trying to figure out, well, can he run for the board or can she run for the board? What can we do to prevent this? And I think that some, excuse me, some board members kind of took it in their own hands to try to levy, I don't want to say bogus fines, but to try to levy some charges, maybe at the last minute before the filing deadline. And then they could point and say, oh, well, we have this charge on your account that you didn't pay, you're delinquent in paying a monetary obligation and you can't run for the board. So this was intended, I think, to, again, curtail those situations, and specifies that only a delinquency of an assessment rather than any monetary obligation at large would prohibit someone from being a candidate. Interestingly, the Condo Act and HOA Act both state that once you are a board member, if you become delinquent in payment of any monetary obligation, you are considered to have vacated your seat. I don't know what the justification for that discrepancy is now with this change. I don't know if it's an oversight or maybe there is a reason that I don't recognize, but that's something I wouldn't be surprised if we see change. To me, it doesn't make sense if you're prohibiting someone from being a candidate for non-payment of an assessment, but non-payment of a monetary obligation is okay. You would think that once they're on the board, the same rule would apply, but that is not the case right now. If you are on the board and you're delinquent in the payment of any monetary obligation at large, you're considered to have vacated your seat. So just an interesting, what I would consider a discrepancy there. Senate Bill 1966, the next thing it did was it gives the DBPR the ability to adopt rules regarding submission of a complaint against an association. Hopefully we'll see them act on this rulemaking authority, because as I'm sure some of you all know, it would be very helpful, I think, to have some rules in place for, how frequently, or what level, of wrongdoing a person needs to allege before submitting a complaint. Unfortunately, I have seen a lot of bogus complaints filed, and those are, I say, it's unfortunate, one, because, of course, no one wants to deal with it, but a lot of the time, the association, if you get filed with a petition, a DBPR complaint filed against you, you're probably going to need to pick up the phone, call your legal counsel. Managers are going to have to deal with it too. This takes a lot of time, resources, and money of the association. So hopefully we will see the DBPR implement some rules regarding submitting complaints against associations. And this next one, annual budget must be adopted at least 14 days prior to the start of the association's fiscal year. I think most communities in their documents have language to this effect anyway, at least 14 days. Sometimes I've seen, an entire month. But I think this is just another situation in which I think the statute was maybe inadvertently silent on it, and they just saw that and wanted to take at least some stab at fixing it and setting a default at 14 days. Again, most situations, I think you're probably adopting your budget, more than 14 days in advance. At a minimum, you've held, board meetings discussing the budget. So, and that's the same is true in co-ops there. That's that last bullet point there. Co-ops also have a default now of 14 days for adopting the budget for the association's next fiscal year. I have seen situations where the association didn't adopt a budget for whatever reason before the start of the next fiscal year. And as I'm sure some of you all know, when that does happen, the prior year's budget automatically rolls over into the next year. It doesn't happen a lot, but I have seen that happen. So this next one, Senate Bill 76, and I think this is the last bill that we're covering before we get to some of the questions. But Senate Bill 76, this really doesn't have a direct impact on your condo, co-op, or HOA acts. But the DBPR wanted to include this. This is one of those mandatory bills that they require in the course, probably because they want to make sure that the targeted individuals, the contractors and public adjusters who this is, intended to address, know that it's being taught. It's kind of a cautionary tale, I think, to them. But basically, this rule was implemented to prevent situations where contractors and public adjusters are going out and putting door hangers on, your association doors and encouraging associations and their members to file insurance claims. The other thing that, and this is something to kind of tuck away and keep in mind. So it does reduce the time frame that an insurance claim can be filed, a new claim or a reopened property insurance claim. And it was previously 3 years, and this is now reduced to 2 years from the date of loss. So keep that in mind, knock on wood, we're still in the midst of hurricane season, and hopefully this won't be relevant this year. But of course, it takes one bad hurricane to roll through, and this becomes very, very relevant. And really all kinds of property insurance claims. But keep that 2-year deadline in mind, because that is a hard deadline. Supplemental claims are still 3 years, which they were previously 3 years, but this is the new or reopened property claims are now 2 years from the date of loss. They have to be filed. And these last 2 bullet points, I don't want to get in the weeds. This is really more directed at the attorneys who handle these insurance litigation claims, but it affects how attorneys' fees are calculated and basically substantiating, improving those fees, and allows for consolidation of cases. So just a way to ease up the court dockets from the arduous insurance policy claims that you see in there. So before we jump, we're at 7:13 right now. So before we jump over to questions that have come in and comments, I do want to do just a kind of a brief primer on what we might expect to see next year. So as I mentioned earlier, obviously, no one wants to see what happened in Surfside happen ever again. And there's a lot of discussion right now about how we prevent something like that happening, and what legislation can or should be enacted to try to address those situations. So the first thing that I wanted to talk about, and this is, of course, in condominiums, not HOAs, but the Condominium Act gives owners by a membership vote the ability to waive reserves. And to me, it probably needs to be revised. I think that most of your condominium owners see, if you get a letter that says, okay, you can pay this amount or this amount, which is less, they might not really appreciate what they're agreeing to when they waive reserves. They might not really realize that what they're agreeing to is underfund their own property interest and, underfund some maintenance that might need to be done, and, structural integrity, engineer reports and things like that. So I wouldn't be surprised if we see some legislation proposed that limits the owner's ability to waive reserves. I don't know exactly. I don't think it would completely prohibit the ability to waive reserves. Maybe it would increase or set a minimum membership vote or something like that. But, I'm speculating, but this is kind of the chatter I've heard. It's been discussed. I wouldn't be surprised if we see something addressing that. And the next kind of prong in response to Surfside, there's been a lot, I'm sure you all have seen in the news, there's been a lot of coverage on structural recertification and when that has to be done, and the lack, frankly, of oversight and the lack of rules that currently exist in most municipalities. This one, I think, gets a little bit trickier. I don't know that we'll see this take effect next year or even proposed. I have my concerns with requiring something like this because, of course, it takes funding. And, if you have an association with a limited budget, you might need to pass a special assessment to fund something like this. If there's a law enacted that says you're required to get recertified or do an inspection every 10, 15 years, 20 years, whatever it is, that takes money. And it's not as simple as just telling associations they have to do it. There's of course, a lot of inner workings there where you might need to get a membership vote. You need to figure out how you're going to fund that. I think this will probably be left to your local municipalities, as maybe it should, because although your coastal water lines might see more issues with structural integrity being compromised, more inland counties and communities might not need the same level of recertification every 10, 15 years. They might be good going every 50 years. So just a couple things that, I did want to touch on. I've had a lot of clients ask about, Surfside and how that affects condominiums. And of course, it remains to be seen, but some speculation and based on, what I've heard and things they've discussed. And then the next portion of this too, of course, you always have some cleanup that gets done. And I've kind of discussed while we went through the bills, some of the things that I think will be introduced maybe to make the acts consistent across the board or within themselves. One thing is that board eligibility in HOAs and limiting, in condos, and expanding that to the HOA Act. It doesn't really make sense to me to limit the delinquency ineligibility to assessments in condos only. I would think the same logic would apply in HOAs. And furthermore, if you're serving on the board and you fall delinquent in the payment of monetary obligations, to me, I don't really understand why you can run for the board if you're delinquent for monetary obligations, but once you get on the board, you immediately, I guess, vacate your seat. In condos, that's how that reads now. So to me, that's just inconsistent. I think it probably needs to be cleaned up. If if they notice it, I think we could see some changes there. And then the next thing, this method of delivery change, and this was what we discussed with when we discussed the Condominium Act, and this applies to the HOAs, condos, and co-ops. The method of delivery, which now requires, as we discussed, that the association get written approval from a member before the association changes its method of delivery, delivering those statements of account and invoices. In theory, I don't think this is necessarily a bad rule or change, but my concern is the mechanics of it, because like I said, oftentimes this is brought on by owners who reach out and say that they want a different address used. And so it doesn't really make sense to me to have that 30-day waiting period. To me, that needs to be shortened or, just revised to fit the daily practice of how notices and the communication actually plays out. Again, like I mentioned, I think that we're going to see the emergency powers section adapted to the current situation that we're in, where we don't rise to the level of being a state of emergency, but we still, of course, have lingering restrictions on, some of the ability to, whether it's meet in person or, some of these holding annual meetings, holding elections, things like that. So I think we'll see some more changes to the emergency powers. My understanding is that the law that was enacted was highly edited and tailored down from what was initially proposed. So it kind of leads me into my next bullet point here. One of the best, ways to get an idea of what's coming up is to look over legislation that failed. The legislation that we covered today, a lot of this is, rarely is something introduced for the first time and passed right away. A lot of this legislation is has been years of effort and revising, and maybe it didn't pass last year or the year prior. It came back around this year, and they were able to agree on the terms and it got passed through. So with that being said, that again, that covers the mandatory material, and there are plenty of legislative update courses out there that you can take. And in my opinion, I think it's good to take as many as you can, because you'll probably learn something each time you do it, not only from the instructors, but also just from questions and comments that you get from the other attendees. There are other acts that, tangentially touch on condo and HOA operations, but these are the primary bills that the DBPR wanted covered, and I think it gave us plenty of material. But you can certainly, do some research out there, become a Google scholar, and I'm sure that you'll find more information, if you're interested in this type of thing and you want to see other legislation that, like I said, tangentially, even if only slightly, can affect the condo and HOA and co-op operations. So with that being said, I think if we want to start kind of jumping into some of the questions, and of course, James, if you have anything that you want to add or correct about what I covered, but I think we're ready to jump into some questions.
Colby, I'd like to thank you for the wealth of information you shared with not just our attendees this evening, but also with myself. it's always interesting. I attend a number of these courses and webinars over the course of a year, and a lot of them will from time to time cover the same core curriculum, if you will, but I always pick up a little extra bit of knowledge out of them. So I appreciate that, and just want you to know that, you know, we as industry professionals see the value in what you're providing for us. We do have some questions that I'd like to bounce off of you on behalf of our attendees, some of which do pertain to the subject matter discussed tonight, but also to miscellaneous questions. Concerning Senate Bill 56, specifically to the notice of late assessment, you'd stated that prior to the association being able to collect, attorneys' fees imposed by management companies relative to collection efforts, the notice needs to be sent. Does this also pertain to fees that might be imposed by a collection agency should the association employ one?
My answer would be no, because the way that the law is written, it specifically says attorney's fees. So unless there was a situation, in my experience, those collection agencies typically, it's not categorized as attorney's fees. They don't use an attorney for, those letters. They should be able to still recover those from owner accounts.
Second one I see on here, and this is more so with respect to the litigation process for an association. I believe I know the answer, but I'm not admitted to the Florida bar, so I'm not going to respond. Subsequent to, if there's a suit filed between an owner and the association, either way, subsequent to any mediation, is there a requirement for it to go to pre-suit arbitration?
No, you don't have to do both of those things. In other words, so if you mediate it and it's not resolved, you don't have to then go to arbitration. Is that what they asked?
Yes, effectively,
Right.
yes.
Okay.
Prior to going in front of a jury, if you will, or a judge. Let me continue here. Pardon me. With respect to the pool matter you touched on, one of our attendees wanted to know if they understood you correctly in that, can swimming pool rules not prohibit minors from utilizing the bathing facility without adult supervision?
I will answer this cautiously, let me say. I have had almost identical questions from clients, and I have said basically, I think there's an argument that that's discriminatory. The way that I advise clients to handle situations like that, instead of drafting the rule with the age of the people being, the triggering, event, if you're trying to prohibit certain behavior, speak to that prohibited behavior instead. So I've told clients, if your concern is with, minors running around the pool or, something like that, I mean, I think I've seen communities say something like no horseplay, so it's just a way to directly address the behavior and issue that you're really trying to address without roping in age, because there's no, you can draft it in a way that you avoid even opening that avenue of an argument. But I would say on its face, if you have a rule that, uses age as the basis for enforcing it, you could face, I think, some discrimination arguments for sure.
Thank you. Concerning the retention of official records, can they be digitized and maintained exclusively in electronic format, or need the association maintain the original physical hard copies?
The Act still states that the records need to be maintained and made available within, I think it's 45 miles of the association. In practice, if you make them available electronically, you're probably not going to have further issues from an owner. With that being said, I would say this is a case-by-case basis. More and more, we're going to see more technology used for these types of things, and it's obviously less burdensome to the association and, frankly, I think to the owner. So that's why I think a lot of these things will get resolved, on their own. But it's case by case. So if you have an owner, maybe, they're older, or I'm younger and I'm not great at technology. If you have someone who's not comfortable using an app for whatever reason, if they have struggles with accessing that, you still want to have a physical copy to make it available. I don't think that associations should take this as, okay, we're just going to upload everything and call it a day. I think the best practice is still to have those physical copies.
Thank you. We have a few more here, if you would entertain such. If there is an association with bylaws which call for a 7-member board of directors, but due to resignation, there's only 6 sitting, even if there are multiple qualified candidates who might be interested in filling that position, would the board be in a dereliction of duty by not appointing that 7th director? My experience, that's largely dependent on the language in the bylaws, but again, you're the qualified professional.
I agree with you, James. I think you'd have to look at the bylaws there. It does typically state that the board of directors shall, I see that word used a lot, shall appoint someone to fill the vacancy. If you have people willing to serve, I would interpret that as needing to fill that vacancy. That's how I would interpret it. Now, again, case by case basis, if there's an election next week, you might be able to justify kind of holding off on that. So, fact specific circumstances could justify waiting. But in general, I think they need to appoint someone to fill that vacancy.
You. And let me see if we have anything further here. Don't see anything additional in the chat panel. There were some questions that I entertained.
And while you're looking, I'll add, I'm planning to, of course, this PowerPoint is available as a handout, and I'm happy to email this to whoever would like it. But I was also planning to draft up a handout that will have specific sections. In my experience, it's just can be a little dense to include a bunch of numbered sections, but it's really useful to have as like a PDF after the fact, because I think everyone's probably an advocate for that Control F feature where you can search terms in a document. So that will be forthcoming probably next week.
There's great value to be had in quick reference guides. Well, again, Colby, I'd like to thank you for spending your time this evening and providing the information you've had. Certainly, answering questions on behalf of our existing clients, and also associations we'd hope to partner with in the near future. Again, I know I found this a very valuable use of my time, and look forward to our next webinar.
Thank you. Thank you all so much for having me. And thank you again to the participants who joined us. And yeah, if you have any questions, feel free to reach out to me. I think we've got our contact info on this next slide. Yeah, there we go. So if you have any questions, certainly feel free to reach out to me. I'm kind of a nerd. This is what I do, and I enjoy talking about it. So it's just some pleasure reading for me.
And for everyone else, all of our attendees, thank you for coming on this evening. We enjoy this webinar. Thank you again, Colby and James, for hosting, for moderating. And as I mentioned earlier at the beginning of the webinar and in the chat, if you have any questions related to this particular webinar, Colby's information is there, James's information is there. But also you can email us at webinar@vestapropertyservices.com. And again, a copy of the recording and the documents Colby mentioned will be available in the next few days. And hang on, as soon as we end this webinar, you'll all receive a survey.
Thanks, Leslie.
Thank you, Leslie.
Thank you all.
Everybody have a good evening. Thank you.
Thank you.